The New York Times reported that the Department of Defense is blocking the Biden administration from sharing intelligence and evidence of crimes committed by Russia in Ukraine with the International Criminal Court. That may seem a bit odd, given the fact that the Biden administration has publicly stated that it believes Russia has committed war crimes and potentially other atrocities in Ukraine, and that the State Department has publicly said it plans to cooperate with all justice mechanisms, including the International Criminal Court. So why would the DOD try to prevent cooperation with the International Criminal Court? Well, according to the New York Times, it's because they fear it could set a precedent that would allow the court to investigate the United States. Now, to understand how ridiculous that notion is, we first have to discuss what the International Criminal Court, or ICC, is, and what it is not able to prosecute, and what their jurisdiction is. So the ICC was created by the Rome Treaty, and under the Rome Statute, the ICC only has the ability to prosecute the crimes of genocide, war crimes, crimes against humanity, and the crime of aggression. Genocide, war crimes, and crimes against humanity are often referred to as mass atrocities or mass atrocity crimes. I made another video talking about these different crimes and have written a few pieces about it that I'll link in the description below. The ICC is known as the court of last resort because the ICC acts to complement national justice systems and is only able to prosecute cases when a state is unwilling or unable to do so. The ICC also has a limited jurisdiction over where it can investigate and who it can prosecute. Now this gets a little confusing, so try to bear with me. Countries that are a state party to the Rome Statute, meaning that they have signed and ratified the treaty, can request an investigation by the ICC. A government that is not a party to the Rome Statute may allow the ICC to prosecute crimes committed in their country or by one of their citizens. The United Nations Security Council can also refer a situation to the ICC, as was done in Darfur, Sudan in 2005. Finally, the Office of the Prosecutor may request permission from the pretrial chamber judges to open an investigation into a case. However, the jurisdiction is still limited to crimes that may have been committed in a state party's territory, by nationals of a state party, or in a state that has accepted the ICC's jurisdiction. The United States is not a party to the Rome Statute, and therefore is generally not subjected to the jurisdiction of the ICC, unless under certain circumstances, as I just mentioned. So to recap, the ICC can only investigate and prosecute mass atrocity crimes and the crime of aggression, and it can only do so in a limited jurisdiction, and only if a state is unwilling or unable to prosecute suspects themselves. So why exactly is the Department of Defense nervous about prosecutions from the ICC? Sharing information with the ICC about the situation in Ukraine wouldn't somehow open a backdoor for the ICC to prosecute Americans. It's a ridiculous thought. The only reason we should fear the ICC is if the DOD was planning on committing mass atrocities or the crime of aggression, and wasn't planning on holding anyone accountable. Now, we all know that the United States, unfortunately, regularly violates international law. Just look at the torture program, the rendition program, indefinite detention, and several other crimes associated with the use of drone strikes. And sadly, there hasn't been much accountability for most of these violations. The DOD could also be a little hesitant to work with the ICC because in 2020, the former ICC prosecutor sought permission to open an investigation into crimes committed in Afghanistan by Taliban, Afghan, and US troops. The Trump administration did not take kindly to that investigation, and it responded with the unprecedented move of sanctioning the ICC prosecutor using the Specially Designated Nationals list, a tool that's often used to sanction violent criminals like terrorists and drug traffickers. The Biden administration lifted those sanctions, and the ICC prosecutor, the current prosecutor, announced that he was going to be deprioritizing the investigation into alleged crimes committed by US forces in Afghanistan. Now, advocacy organizations like the ACLU and Human Rights Watch have denounced this decision, arguing that doing so harms the ICC's credibility and victims' pursuit of justice and accountability. But this wasn't the first time that the US has had a rocky relationship with the ICC. Despite the US's history of supporting justice from Nuremberg to the Tokyo trials to the ad hoc tribunals for the former Yugoslavia and Rwanda, the US government has been standoffish towards the ICC and even at times worked to undermine the court. President Clinton, in one of his last major actions as president, signed on to the Rome Statute on December 31st, 2000. In doing so, he expressed his concerns about the court, but also stated, "I believe that a properly constituted and structured international criminal court would make a profound contribution in deterring egregious human rights abuses worldwide." When a state signs on to a treaty, they are basically saying that they intend to ratify the treaty at a later date, and in the meantime will not do anything to directly violate the intentions of that treaty. Well, in 2002, President Bush took the unprecedented and somewhat hollow step of basically unsigning the US from that treaty. It's not really something that you can do, but John Bolton wrote to the Secretary General of the United Nations to inform him that the US had no intention of joining the ICC, and that the signature was basically meaningless. But Bush didn't stop there. The administration undertook a bullying or blackmail campaign, pushing countries around the world to sign bilateral agreements with the United States, guaranteeing that they would not surrender any American citizen to the ICC for prosecution. In exchange, the U.S. would continue providing various forms of economic and military support. Congress also took action by passing into law the American Service Members Protection Act of 2002, which included a very controversial clause that gave the authority to the president to use force to free Americans from the ICC if they were being held by the court. Critics of this clause and the law have referred to it as the Hague Invasion Act, due to the ICC's location at The Hague. Representative Ilhan Omar has introduced the Repeal Hague Invasion Act, which would repeal the bill, but it does not have strong support outside some other progressive Democrats in the House. However, in light of the war in Ukraine, there's been some bipartisan effort to ensure that the U.S. could cooperate with the ICC and ensure that Russia would be held accountable for crimes committed in Ukraine. Last year, Congress passed a provision in the Consolidated Appropriations Act that provided an exemption to the Armed Service Members Protection Act. This exemption, specifically for Ukraine, should have paved the way for cooperation with the ICC. But it seems like the DOD is still trying to stonewall that effort. President Biden should work swiftly to ensure that the cooperation from the entire federal government is given to the ICC, so that we can share evidence of crimes committed in Ukraine and hold violators accountable. In the long term, Americans need to push for the ratification of the Rome Statute. It's long past time that the United States joined the ICC. We should not fear universal justice for some of the worst crimes in international law, and the U.S. should not consider itself to be above international law, while simultaneously trying to enforce that law on other states.